Okay, Amy.
My name's Amy Ruthig. I'm the zoning official of Genoa Township.
Okay, Patty.
My name is Patty Thomas. I'm the recording secretary.
Okay, I think that's everyone that we normally introduce. The next item on the agenda is the approval of the agenda. Can I have a motion to approve the agenda? Please state your name when you make the motion.
Jean Ledford, I approve of the agenda.
Bill Rockwell, second.
All right, I have a motion and a second. Is there any discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Is there any opposed? Okay, great. We have an agenda. All right, the next item on the agenda is to call the public. This is to call the public for anyone to speak on an item that's not on the agenda. There are two options to comment. One is to call the phone number on the screen. Enter the meeting number and password and press 9 to raise your hand. You can go to the website listed on the screen, and the technical support number is also on the screen. When you call or when you answer, oh, okay, that's just for me. Okay, so we'll wait a minute here. I apologize for the dog barking. We'll give everyone a minute to call in here. All right, we'll wait another 30 seconds. All right, seeing no one has called in, I'll close the call to the public. If someone should call in the next few minutes, we'll definitely accept their call and reopen call to public. This brings us to, so we'll close call to the public. This brings us to the first item on our agenda, case 2027, a request by Todd Krebs of 4222 Bower Road for a rear yard setback variance size variant. Rear yard setback variance, size variance, and a height variance to demolish an existing attached accessory structure and construct a new accessory structure. I ask that those making presentations tonight
Did we lose audio?
We lost Greg.
Okay.
Did he disconnect or?
I still see him on here. It just shows his audio is not on, but it shows he's on video.
Greg, I think you accidentally unmuted or accidentally muted yourself.
He lost video. He's having internet connection, I bet.
Okay, where was I? Oh, addressing the public safety and the impact on the surrounding neighborhood. All right, so with that, is there anyone here to represent Mr. Krebs tonight?
As chairman, sorry, you faded out on us, so I think we totally missed everything you just said. I think you were explaining the
Okay.
requirements for variances. Would you be so kind as to indulge us again to repeat? them?
Right. So when you make your presentation, sure. When you make your presentation tonight, I ask that you address the 4 issues that will determine whether your variance is allowed. They are the practical difficulty and the substantial justice that would be achieved by granting you the variance, the extraordinary circumstances associated with your property that deem the variance necessary, and how granting the variance would impact public safety and welfare, and the impact on the surrounding neighborhood. Those are the 4 issues that we will take into account in granting your variance. At this time, we'll start with Mr. Krebs' case. Is there anyone here to represent Mr. Krebs tonight?
Yes, Mr. Krebs is here. So first of all, thank you. I appreciate everyone going through all these hurdles to make this happen. I'll try to be brief because we attempted to put all the pertinent information into the package, and we were under advisement as well, and I think we got some good advice. So we tried to keep it focused on those 4 items. A little bit of the background, I guess, is that we've actually owned the property for 6 years. We bought it with the intention of renovating it and retiring there, which is still our intention, but there's a couple items that obviously we'd like a 2-car garage or something. A multiple vehicle garage is one of the biggest hurdles we've hit. It is zoned LDR, which is in the packet from Amy. In this case, though, it's a half-acre lot and it's only 87 feet wide. So that causes a lot of issues, quite honestly. Up until this time, until October, we had planned to purchase additional property and to add to the existing house. And maybe jumping to page 14, which Amy is already showing here, I think this is Amy. We thought we could add on to the end of the house and have a side entrance garage. So we tear down the current attached garage, flip it around, do a nice side entrance, and have that, which it would have been a large garage, a 30-foot by 40-foot garage with a side entrance, which is kind of more the typical construction that you will often see now. And we worked with Kelly to try to come up with some alternative solutions. If Amy could jump to page 21 and 22. I don't know if, I think the pages are the same, yeah. So Kelly was helpful. We looked at some of these things, trying to do it so we wanted to have a conforming building. Currently, the house right now is not conforming because it's only about 9 feet on one side and 14 feet on the other, whereas LDR requires 30 feet on each side. So that's already a non-conforming building. And obviously the outbuilding out back is non-conforming as well. So we would have greatly preferred to have something attached. I think that's a general statement for everyone. So with that, I think just briefly talk about the staff report and the possible finding. This is one of the places I think it's really helpful to actually visit the area. So I don't know how many on the board have made a physical site visit, but it helps to see it. There's only so much you can put in pictures. But the current outbuilding, as I said, is non-conforming in both the rear setback, which is, I'm used to having a pointer and I don't have a pointer here, but that's in the back corner for those that were there. Thank you, Amy. Yes, so that's the current building. It's non-conforming in both side and rear setback. And what we're proposing, and this now in consultation, we actually want to change this again, is that I can tell you that we would like to remove the square footage variance request. It's only a 60-foot override, and it's not material to our ultimate goal of what we're looking for. So I don't know how that impacts the ultimate thing, but that we're only requesting 2 variances, which was our original request working through Amy. The square footage is less than the encroachment that we have in our front yard, but as I was advised, those are absolutely two separate issues that need to be addressed at separate times. So what's unique about this, the topographic, the slope and everything has already been mentioned, but the rear location of the building, which is points 5 and 6 there, those are 11 feet below the baseline grade already from what we'd be looking at. And if you go there, that bottom corner, which I didn't put it all in there, like down where the notes are at, it continues to slope away. So we're not building up on any kind of elevator. It's in a valley. I don't know what to call it, but it's definitely slopes away. So, and if you go to page 13, oh, it's turned, but that's not the current configuration at all. And that's what, we were originally told in the meeting on March 11th, I think it was, that they would be keeping the same center line of road. And that's the last we heard until construction went in. What actually is happening is page 16. So you get an idea of that it's substantially different than what we were told would be installed there. And that doesn't show the topographical, but the road is at a much higher elevation than the backyard. And in fact, when you come around that road, the lights from vehicles, we noticed this working in the house, shine directly across the back of our house and into the two windows on the side for our bedroom. Eventually the trees will get high enough. They grow about a foot a year, but right now they don't block because of the angles. For those that were there and you drive on it, you get an idea right away of what's going on. So one of the things that's been pointed out to me is that it does say substantial justice, and that is subjective. What is substantial justice, and what is that possessed by other properties? It's extremely difficult to find another property in this area that doesn't have a 2-car attached garage. And in fact, it's a requirement for most places. And this is not our original goal or anything. It's what reviewing with architects and a lawyer said, well, this Stephen Covey began with the end in mind. What's your goal? This was the best we saw to make it work. And that's what we're going for. Like I said, it's been 6 years. This is kind of like, okay, we got to figure out something or just renovate it and figure out what we're going to do. So if you go to page 8, so there are all the things that I think anyone would go through and say, yeah, those are a negative impact to our property, of which we had, in many cases, no notification of, some of which required a variance on behalf of the township. And at the end of the day, they impacted us negatively. So if you go to page 12, Amy had some conditions. And I can certainly, I don't know if the right words testify, I don't know if I'm not under oath, I guess, but we would certainly agree to those two conditions. We're not looking to occupy this building. I have a skid steer, we have a camper, and our second vehicle would be going in there. It's would be a garage. We're already talking with an architect, designer that I got put in touch with by talking to another person that went through this process. And we'd want to have something that looks nice. By the way, the drawings in there were only to meet the check boxes. That's not what we would do as a final structure. Yeah, that, because it said you had to have a drawing showing the heights. But that's not, we'd look to do something, and we're going to tour, we've been talking quite a bit, Mr. Wilson's place on Bauer, although this would be substantially smaller and we would not be connecting to the house. We'd want something that would fit in with the surroundings. And I think that can be spelled out with the land use and, the other requirements. So we're amenable to saying that you have to do certain things with this building for appearance wise. So with that, I guess I can take questions.
This is Michelle. Can I take the first one here?
Yes.
Okay. You had just mentioned then you were going to change your requests. Can you spell that out, Amy, as far as do you still wanted the 22 feet building height? Are you
Yes.
changing the length or the width? That's what I would want to know exactly what the new square footage is minus, what your,
Oh, if you need the exact, I guess 900 or less. I mean, we're not going over the 900.
okay. So it's not between 900 and 960 then?
No, I'm certain. No, we would meet the 900 requirement or less.
Okay.
I wasn't trying to.
Do we still need the height then?
Yes, because of the.
Match that? I mean, I didn't know if you're bringing it down and leave, how you're getting that.
We would still want the height, especially start looking at a dormer or something.
Okay. And then lastly, your approach is going to be down that hill and around towards the north, enter on the north side of that building?
Yeah, if we go to Amy, page 14, if you could please. Oh, that is kind of convoluted. Yeah, if you go to,
You're leaving a tree, is that what I'm wondering what?
yeah, I really want to,
navigate that
yes, my
hill?
wife and I really like that tree. It's a large oak tree and we'd like to keep it because so many got taken out. So if you look at that green dots, you're coming down and around. Yes, you
Okay.
circle around the tree. The tree
Okay.
stays.
Got it. Thank you.
Any other questions, Michelle?
No, well, I guess my last one, I was there with that slope. Do you have to remove or regrade back there?
Oh, yeah.
Okay, I mean, I
Yeah.
noticed how you said it was washing away and then will that be affecting the height then at that point where you're regrading or leveling that out?
It would not, at 0.6 is the highest location, which you were
Okay.
there, you can kind of see, it all flows down to that huge drainage area.
Okay, so there is a
I'm
natural,
not, yeah, everything from there flows down into that huge basin.
okay,
The elevation at 6, I would establish as the floor, if you will. I'm not building that up at all. I do have to bring some fill into the back corner because it drops down another 4 feet.
Okay.
But we're also cutting a lot along the garage because we're going to cut from, if you saw the new driveway and stuff and that edge, I've talked to the guy who did that. He would cut down from the edge of that, bring it all the way down to like where the green line is, I guess, kind of, just past the tree. So it'd be a much gradual slope because right now you go past the end of the garage and then you go down. We'd be taking out that steep slope and making it a slope kind of from where the base, just past the tree up to the current cement. Does that make sense?
yeah, my main concern was the width that you had between the property line for a new drive and all of that, but that's not in regards to your structure at this point. So I'm good with that. I just wanted to make sure your entrance, when you said you might have changed, it was still going to be on the north side.
Oh, yeah.
Okay.
Yeah, to come in from the other side is now just about impossible without
Thank you.
excessive work.
Okay, thank you. Mary Ann, Bill?
This is Mary Ann. I just have a question for you regarding two things. Is you're not planning on grading any of that area in between the proposed outbuilding and where your septic field is, correct? That's staying, that grade is staying?
Correct. Well, yes, between the building, yes. In the far, well, now I wouldn't need to do as much because the building's going to be shorter. When you look at that dotted yellow area, the yellow rectangle, the lower corner towards the rear of the property. Yes, I think Amy's, yeah, right there, it starts to get a couple feet lower.
Yes, it does.
So that needs dirt, and we're going to try to bring it out from where we're putting in the drive on the north edge.
And you have in the backyard right now, you have a couple of buckets over, there's a PVC that's is in the ground that's opened. Is that for like a riser, in your back for your septic?
Yes, that's
tank
exactly what, it's a riser to the tank, yes.
there? Okay. And so you have 2 tanks back there, right?
There's only one, but it might be a 2-tank system. I've been working with Wellman on that, and they did it for me when we bought it 6 years ago
Okay,
and looked at the system, and the whole system again drains towards that basin.
right. You just have a pipe right now that's just above the grade that is open, and for safety purposes, you might want to put something around that so people,
Yeah, yes, absolutely. Yeah, I accidentally drove over it once and cracked the cover.
so the other question I have for you is, what is the hardship that would require you to need an accessory building that is taller than what the allowance is for your zoning?
Because if we were to attach, as most LDRs can, you would have an attached garage to the house and everything. You're actually allowed 35 feet, and I certainly don't need 35 feet, and that would be an eyesore. But with the original plan and what we had looked at, we would have been able to do that. And that was a big part of our plan, is to be able to have that. So we looked at this and said, okay, because we can't do that, because originally back in the 60s, they made this a tiny half-acre narrow slice. And, even if they'd have went wider, we'd have been okay. But because of how it was subdivided in the 1960s, and because of the topographical nature of it, where we're at, it is hilly. There's no other way around. I mean, it's literally been a 6-year trying to figure something out, and we kind of reached the point where we exhausted everything.
Right, but it's still, I'm trying to figure out why, just because you're not putting an addition on the side for a garage, what's the hardship that would say it's justifiable, it's going to give you substantial justice to build this accessory building that's larger, taller than the other similar properties in the surrounding area?
Because when those variances were put in, they were put in with generally the assumption that's on a flat surface. And that's what the ordinances are for. And they're to prevent really, the legal term I'm sure is not eyesores, but to have respect for the neighbors. And in this case, because of the 11-foot difference, it's, 14 would be higher.
Any other questions, Marianne?
No, thank you.
Bill or Jean?
No questions. Thank you.
Bill?
Guess I just wanted to understand a little more with regards to the building height. The reason that you're asking for 6 feet above our requirement is because you're going to try to make this taller specifically for RV parking, or was it because of making this a potentially 2-story
Part of it
space or what have you? Because in this picture that she's put up, it's a generic picture, but I'm trying to determine, are we trying to really squeeze in a 2-story structure here, or make an RV, massive garage opening there?
Well, yeah, the latest design is actually 2 garage doors, one normal size, one larger. At least that's what it was a couple days ago, what we'd be looking at. No, we're not looking at a 2-story per se, except on the end. I have a workshop, I don't know, I guess you guys didn't get to go in the building, but all the cabinets, everything in the house, I did. I do cabinetry work. So I built all the cabinets for the bathrooms and the kitchens, any place else. And the lumber out front right now is going to be for custom mantles for the 2 fireplaces in the house. So I'd like to move my workshop into the building. That's a long-term plan, to use the other end as a workshop.
Okay.
it beats having to move all or 2 cars out every time I want.
I have one question. What will be the height of this, what will be the height of the accessory structure relative to the rear height of the home?
It's slower, but I didn't do that. I'm sorry. I can.
I would like to know what the height relative to the rear of the building, measuring from the grade of the rear of the home. What will be the height of the building in comparison? Will it exceed the height in any way of the home?
It would not, and you can put that, I guess, in any kind of stipulation that it cannot do that. I don't, as an engineer.
What is the height of the current building?
You broke up there, Greg. Was the question, what is the height of the current building? The current.
Well, what is the height of the building he's proposing? The drawing indicates 3 different heights.
To the very tippy top would be 24. The very peak would be 24.
I don't want the peak of the accessory building exceeding the peak of the home.
Right, and it would not, but that can be a stipulation for sure.
Okay. Does anyone else on the board have any questions?
I guess that's my question too. We've got a setback, a height variance for 22. And if it's going to be 24 at the peak, do we have to have this specified before we, we've changed things kind of on the fly here. I just want to make sure when this is approved, it was a good question, Greg. If you're going higher than 22.
You put in something building must not exceed some, in addition or something, I'm okay with that. Provided, maybe if the variance is granted, provided that it does not, the less of 2 numbers.
Amy, how specific does it have to be as we approve this?
Specific. I have to have something to go off of when he comes in for the land use permit.
So is it best that we request that he go back, or can we just put a condition that cannot exceed the height of the rear home?
Well, if you do that, then you got to take into account what's the grade difference between the rear of the home to where the new building's going to be.
Right. Most of the building, it's not all the way in the bottom of that depression in the backyard. And I don't think if we do grant the variance, I don't think anyone wants the peak of the accessory structure exceeding, from a visual view from the front of the home,
I agree.
the accessory building height exceeding the height of the home.
I agree with that as well. I'm just wondering if, like, when you order trusses and you get a kit build, that's the only thing. I don't know, as long as you're keeping it to 900 square feet, not to exceed, if that is adequate to approve a variance.
All right, well, we can discuss that when we bring it back up for discussion. Is there anyone who has any questions before I open to the public?
No.
Okay, at this time, I'll open to the call to the public. Is there anybody here to speak on case 2027? Referring back to the phone number on the screen, please call that number on the screen and enter the meeting number and password and press 9 to raise your hand. Okay, we'll wait 1 minute here and see if anybody calls in.
I also think, Mr. Chairman, that if they're doing the meeting through the Zoom app, they would hit Alt-Y to raise their hand if they wish to speak at the call to the
Thank you
public.
very much.
There's a,
Sorry.
That's okay. We all have one apparently.
We do have a call to the public through the Zoom app, which would be
Okay.
Mr. Moretti.
All
Hi,
right.
am I able to ask a question? Can you hear me?
You can, but we don't necessarily have to answer the question.
I had a question for Todd. For that outbuilding, for the grade in your rear yard, it would be like the southwest corner. Do you plan on filling that grade even with the front corner of your garage where your bay doors are gonna be? Where your building height at the peak where you're proposing 24 feet, is it to maintain that height on that southwest corner? Or are you gonna be building a foundation retaining wall on the back to come up with a grade difference, which will result your building being taller? Or are you coming up with dirt there?
Right now, we're coming up with dirt, and that's a question Amy and I discussed. The measurements are only taken off the front of road, which applies to one of the other buildings in the subdivision. I don't know what page that, Amy, if some of the other photos where they have one that's like 2 stories facing a retention pond. So the measurements are very specific in how they're taken. But right now, the short answer is I want it all filled so that there's no wall.
Yeah, so you don't have to spend that extra money in the
Yeah.
foundation.
But I'm not going to continue to fill towards the retention area in that where it's not going to be under the footprint of the outbuilding. And that's why shortening it up actually helps me, because it starts sloping off, like that last 4 or 6 feet is where it really slopes off. And if I suck it back 4 feet, I don't need nearly as much fill in that along the back.
Okay.
I got to the west. I wouldn't need as much fill along the back property line.
Yeah, thank you very much, Mr. Moretti. Patty, do you have everything you need from Mr. Moretti for the minutes?
I do not, sir. I need Mr. Moretti's address, please.
So, I own the adjacent property inside the ridge, would be parcel C.
Just give you your current home address, sir.
Do 4242 Bower Road.
Thank you.
Okay, thank you. All right, is there anyone else willing? Do we have any other calls, Amy, for call to the public?
I do not see any, sir.
Okay, we will close call to the public at this time and bring it back up for the board for discussion and decision. Comments?
this is Mary Ann McCurry. The only comment I have is I'm not convinced that there's a hardship here that would allow the substantial justice for the applicant to have a height variance in the backyard. Just because the backyard has a slope and the grade is lower than what the front of the house is, doesn't give me enough of a vote for approval to be able to say, oh, if there's a slope, it's okay because it's not going to be as high. I'm still looking for that. What's the hardship that, he can't comply with?
I guess respectfully, I would say that the hardship is, had I been able to, if it wasn't for the lot, the 87 feet, it's not an irregular lot legally speaking, but it's an odd shaped lot in terms of the 87 by 250. we would have been able to do an attachment to the house, which would give us 35 feet to work with. So we're constrained by back when they divided us up as a half-acre lot, that we could not do a traditional attached, two-car attached garage. We're fortunate that topographically we can do it and then not have
I don't know
adverse
if that
impact
helps
to
me.
others.
Okay, is there any other discussion from the board? So what are the druthers of the board?
Well, Mr. Chairman, this is Mary Ann McCreary. I would propose a motion for case number 2027 for the property at 4222 Bauer Road to deny the variance for a height and size to construct an accessory structure and remove an existing detached accessory structure, noting that the only thing that would be granted is the rear setback of 6 feet for a 4'6" setback from a required 10 feet. Strict compliance would not prevent the use of the property. Granting the size and height would not be necessary for the preservation and enjoyment of substantial rights possessed by others. Excuse me. Granting the rear variance would give substantial justice as it affords what others in similar zone properties have in the area. And due to the configuration of the lot size, the compliance would be substantial justice to give that variance. Due to the setbacks and lot configuration, total compliance with regulations would prevent the use of a detached structure. And the extraordinary circumstances would be the location of the home on the lot and the topography. The need for the size and height would be self-created. There is no supporting hardship with the property to justify a height and size. This would be the least amount necessary for an impact. And the, excuse me for a minute. Too many papers here, not enough space on my desk. The granting of this variance won't impair an adequate supply of light or air to adjacent properties, or unreasonably increase the congestion in public streets, or increase the danger of fire, or endanger the public safety, comfort, morals, or welfare of the inhabitants of the township of Genoa. And the impact on the surrounding neighborhood. The proposed variance could have an impact on the adjacent neighbors in regards to the surrounding neighbors. And in regards to any requirements that would be a part of this is that the structure would have to be removed completely prior to the certificate of, prior to the building permit issued.
Okay, is that complete the motion, Mary Ann?
Yes.
Is there a second?
Jean Ledford, second.
Just to summarize, your motion is granting the variance for the side setback,
The rear yard setback only.
The rear yard setback is granting. So the motion grants the rear yard setback, but not the size or the height.
Correct.
Okay. There's a motion on the table. Is there any further discussion? Going once. Okay, all those in favor signify by saying aye. Aye.
Can we have a roll call? I'm not sure who I'm hearing.
Yeah. Jean,
Aye.
Mary Ann,
Aye.
Michelle,
Nay.
nay, Bill,
Aye.
and I'll vote aye as well. So the motion passes 4-1. Okay, sorry, Mr. Krebs. That concludes tonight's thing. Do you have any questions?
No, we'll just work with the current building then.
Okay, thank
Thank
you
you.
very much. Good luck to you, sir. All right, that takes us now next on the agenda, case 2018, a request by Ventures Design for 3470 Pine Ridge Land Pool in the required waterfront yard and a variance to construct a retaining wall in the required waterfront yard. Is there, who's here to represent the applicant tonight?
Mr. Chairman, Attorney Andrew Babnick on behalf of Ventures and Mr. Slider, who both are here, Brandon Bertrand from Ventures as well, to answer any additional questions the board may have on the plans.
Okay, both of you are on the same microphone?
No, Mr. Bertrand. Separate.
Mr. Bertrand and Mr. Slider each have their own microphone, correct?
Correct.
I'm dealing with two different. Okay. All right. Do you have any other information? The packet has not been updated, is my understanding, since the last meeting. Is that correct, Amy?
Correct.
All right. So the information was all presented at the last meeting. Does anyone on the board have any questions, or is there any information that the applicant wants to present or re-emphasize again tonight?
Yeah, there are two main points that I'd like to emphasize tonight, if the board will indulge me.
Please go ahead, sir.
So there's two main focus points here, and the first focus point, and Mr. Chairman, I'll leave it up to you if you prefer me to hit on focus point one and then open it up to the board, or if you'd like me to go through both now and then go through the standard, have the board ask the questions thereafter. But there are two main important focus points here. The first is the variance is actually being requested under 230502, which is that there was a misinterpretation or an arbitrary and capricious, erroneous interpretation of the zoning law ordinance. And I provided a letter to the town attorney, and we've had some conversations on this. Article 2502 defines the required yard as the open space between the lot line and the minimum setback. This is key. And this, based on the minutes, I know you guys have had a lot of meetings on this. This is the fourth time that this has come up. But the required yard corresponds to the minimum setback requirement for the district. The section goes on to define non-required yard as the open space between the minimum setback line and the main building. This is very important distinction, minimum versus required. There's been minutes here where the commissioners and the board have agreed that the swimming pool can be put in a waterfront yard, not the front yard, and that the waterfront yard has to be within the shoreline building setbacks. There's an issue within the shoreline building setbacks and what the required yard and non-required yard is. And the board's current interpretation of the ordinance actually creates ambiguity within the ordinance. But the proper interpretation is that the minimum setback is the 40 feet outlined within the ordinance. The reason for this is twofold. By asserting a standard minimum setback, it assures uniform protection for the waterfront property, creating a buffer that's consistent throughout all of the land. Two, it prevents property in compliance with the structures located in non-required yards from suddenly, through no fault of their own, coming out of compliance. And this is best explained by an easy example. My client, had he been able to move the property, and part of the second presentation is why a variance, even if the board continues with its interpretation of required and non-required yards, why a variance should be granted in the hardship. But by example, if my client was able to relocate his property, if he was able to move the home back to create this non-required yard based on the analysis that it's not the minimum 40 feet, but the 80.5 feet based on the analysis of the homes within 500 yards. If he were to do that and build his home, and then a year from now, 2 years from now, come to seek to build a pool and find out that his neighbor moved their home and built at a different location, he could suddenly go from having a non-required yard to having no non-required yard. And that in and of itself, that fluctuation would create chaos within the ordinance. And it's very clear within the ordinance. If you look at Article 25, the definition section, setback, required setback, is defined as the minimum horizontal distance between the building line, front, rear, and side lot line or neutral fence or shoreline. It then specifically says required setbacks are distinct from actual yard. And for yards, you need to review the definition of yard. The distinction between minimum and required is huge. This takes us to the November minutes, where the board came to the conclusion that a swimming pool can be placed in the waterfront yard, but needed to be within the shoreline building setback. Again, very, very clear distinction here in the statute that accessory buildings must be within the shoreline setback and the same requirements as the principal structure. But there's no such requirement on accessory structures. And we see that throughout the lake. We see people who have accessory structures, who have fire pits, they have grills, fire rings, gardens, flagpoles, retaining walls, all within this, what the board would describe as a required yard. So Table 30402 provides the required setback, and this is where we get into this argument over minimum versus required. Table 30402 provides the required setback from the shoreline or the ordinary high water mark for a principal building. The distinction between required and minimum, again, are key. When analyzing a statute, you cannot create ambiguity where one doesn't exist. It provides that the minimum is 40 feet. Principal structures have a required setback that can exceed the minimum, which makes sense. It's logical because they would want to create those sightlines. But the required yard is still defined as the minimum setback, which is the 40. Minimum is always 40. If I have a vacant lot and I build and I ask you, what's the minimum setback from the water? It's going to be 40. This is further supported by Table 30401, which outlines minimum yard setbacks as 40. I know it doesn't specifically say waterfront yards. It only does front, side, and rear. But again, it provides the consistency. The ordinance obviously supports itself. I go back to that hypothetical. My client was to move his home back, which is not possible in this situation, and have the space where now there is a required yard based on this interpretation, or a non-required yard based on this interpretation, excuse me, and then the neighbor were to build at a different location, it could decrease his non-required yard without any fault of his own. He could go from being in compliance to being non-compliance. And I know the counter argument as well, if he builds and he's in compliance and then something changes, it's now a pre-existing non-conformity. That would create an ambiguity in the ordinance that wouldn't have the consistency that the zoning is looking for. In the alternative, assuming the board does not want to change its position on the what I believe to be the proper definition of required yard and how required yard is supposed to be defined, my client would be seeking the variance of 110405, which currently states that only docks, moorings, apparatuses could be built within the required waterfront yard. The purpose here would be to allow an open paved terrace area, decorative landscaping wall. I know it's been qualified as a retaining wall, but it really is a decorative boulder wall, and swimming pools as shown within the plans, which I know no updated plans were submitted, but you guys have seen this ad nauseum now over 4 meetings. As previously stated in November 17th minutes, the zoning administrator asked for an interpretation about this ordinance as it would preclude all structures not listed within 110405. As I said before, we see throughout the area trees, fire rings, grills, gardens, steps, flagpoles, retaining walls. that all would qualify as these accessory structures that exist in this waterfront yard. My client is simply asking to have the same use that everybody else had, which will get me to my argument on hardship. Again, don't need to repeat this, but 110403 does not prohibit pools in the waterfront yard. This was affirmed by the board in the November minutes. So what would be the particular difficulty or the substantial justice? Due to the unique pie shape of the lot, the location of the home is fixed. It can't be moved without needing side yard setback variances, as well as additional retaining walls to allow for the walkout basement or eliminating the walkout basement in its entirety. A normal linear shaped lot, the ability to shift the home would exist, but that we just don't have that luxury here. And that is not created, that's not self-created here because of the severe topography of the property, which had already been mentioned by the board at the prior September meeting. Strict compliance with the side and front yard setbacks leave my client without any non-required yard space based on the board's interpretation of what required yard and non-required is, which leaves them without the same property rights possessed by the other properties in the zoning district. Many lakefront owners have the ability to have these beautiful terraces, these fire pits, these trees, these flagpoles, where based on this interpretation, my client just wouldn't be able to do it. He wouldn't be able to have the same access, the same enjoyment, and there's not really a home on the lake that doesn't have something in that backyard area, which unfortunately, based on the topography and the interpretation of what required and non-required yard is, as it stands right now, it would leave my client with nothing. On the November 17th meeting, the board applied section 10501 for conflicting regulations to state that when any provision provides greater or lesser restrictions, the more restrictive shall govern. Again, based on my interpretation of the statute, we can't create an ambiguity that would create restrictions here. Doing so in this case denies my client the substantial justice for numerous reasons. Simply put, accessory structures such as decks, fences, walls, and pools are all given their own setback requirements in Article 11, all of which are less restrictive than the principal structure, which is written this way intentionally. The definition of a principal structure is different than an accessory structure, and therefore there's no conflict to have both with different setback requirements. The pool that's proposed will provide with the given setback requirements under 110403, and I know based on the minutes of the meeting, there was some confusion in the beginning of whether a pool had its own required setbacks, and it does under 110403. It would do substantial justice to allow my client to enjoy their required yard space in the same manner that others have been granted that permission. For example, when a terrace is built without a required waterfront, it follows the setback requirements of a terrace. When a deck is built in the required waterfront, it follows the same setbacks as a deck. So we're doing the same thing here with the pool. It will follow the same setbacks. In summary, we're asking the board without bias to grant the variance to Article 110405 or to adopt the proper interpretation of what the required and the non-required yard is and find that my client is building in the non-required yard and therefore the plan can be approved and the denial was erroneous with interpretation by the zoning administrator.
All right, you said 2 points. That covered both of them?
Yes. The first one being the interpretation of required and non-required.
Right.
The second one, hitting the key points that are required by the board to show the extraordinary circumstances and the substantial justice.
Does any board member have any questions? No questions. I will note before I open call to the public, all board members received 2 letters stating their objections to the variance today. They were submitted via Amy. Everyone acknowledge that. And if they did not receive those emails. Otherwise, if you receive them, I'll expect no response. All right, seeing no questions, one going once, going twice. Yes.
He was requesting in his point 1 regarding interpretation of required and non-required yard for a principal structure. That has not been published or notified. So I guess the board has to determine how they want to handle that one. Because tonight they're requesting a dimensional variance.
Was told by Mike, this is Brandon.
Yes.
I was told by Mike that, and I went into the township office yesterday and spoke with him, that the reason to support the variance, we can apply for either, and that doesn't need to change and publish. And there's actually there's no application form for in requesting based on for asking for the board's opinion of a interpretation or an erroneous ruling, as long as it does not change the request of the variance, what we are trying to build.
I spoke
You
with
said-
Mike today in regards to that, and there is, because no information was provided to the zoning board. It was directed to the zoning administrator. However, they were looking for an interpretation from the zoning administrator, not the township board.
We're not looking for an interpretation.
Well, you're looking for an interpretation, or you're trying to appeal the administrative decision of the zoning administrator, which is what I believe you came in and asked for yesterday.
Yeah.
So in order to do that, the board would have to see, there's a set thing that has to happen. The board, you would have to submit a notice to the zoning administrator, and then the zoning administrator would have to supply the zoning board of appeals with the information. And there's a different criteria that the zoning board of appeals has to do.
Yeah.
The appeal has to meet to be able to pass. And the board does not have that information tonight.
That's understood. And that's, was the purpose of me asking Mike that question yesterday. So I guess we were given, wrong information. Which in that sense, what do we do? That again, it is different than what we were told by Mike. We have no problem publishing that. We just don't know. I guess that's why I went to figure out the protocol before coming to this meeting.
Correct. So application, let me see here. Interpretation. An appeal may be taken to the Board of Appeals by any person, firm, or corporation, or by any officer, department, board, or bureau affected by a decision of the zoning administrator. Such appeals shall be taken within such time as shall be prescribed by the zoning board of appeals by general rule, by filing with the zoning administrator a notice of appeal specifying the grounds thereof. The zoning administrator shall forthwith transmit to the Board of Appeals all the papers constituting the record upon which the action appealed from was taken.
Okay, I guess I understand that. So where would we go then from here?
So the board, it is at the pleasure of the board if they want to hear the dimensional, keep with the dimensional variance, which is the information they have in front of them, and they can make a ruling on that. And then you can, depending on which way that goes, you can follow the procedures that are in our zoning ordinance for the appeal of the zoning administrator's decision.
So if that is denied, we're still able to apply for a variance based on the administrative decision of the same project.
That is my understanding, correct?
It would be a sure shame if we realized that wasn't the case after the fact.
Correct. I would have to check with council.
Okay, so it doesn't seem like we can safely get anywhere then in this case.
The board has in front of them the dimensional variance request. They do not have anything regarding the appeal of administrative decision.
Yeah, I understand that, which is why, that was the purpose of talking to Mike yesterday. I will point out it's not a dimensional variance request because there is no dimension that we are seeking.
Correct.
It's what we're seeking is relief from 110405. So we're seeking relief from a specific ordinance, not a dimension. But I guess the big question here is if this, the key number one is in this interpretation of required versus non-required yard. From there, we don't want to be denied the opportunity to present that based on a denial for a variance.
What does that mean?
So some clarity in that, sense, I think is kind of needed to dictate which way we go.
Correct.
And you don't think you can provide me with that clarity?
Unfortunately, I believe Mrs. Van Marter spoke with the township attorney today. And I believe your attorney also spoke.
We did.
I do know that our attorney said that he does not believe that that can be heard tonight. Now, if the motion goes forward and it's a denial, I don't, can you readdress for the appeal of the administrative decision? That's a question that I cannot answer. But it looks like Mrs. Van Marter, I believe, is logging on to the meeting. So she might be able to offer some clarity for us.
All right, Mrs. Van Marter, are you there?
Looks like she's connecting to audio. I believe she is on, Mr. Chair.
Was there a question for me? I'm sorry, I just logged in.
Yeah, go ahead, Amy. Could you restate the question there?
If the board makes a decision regarding what is placed in front of them today, regarding the retaining walls and the pool, and if it does go for denial, can the applicant submit not an application, but submit an appeal of an administrative decision?
I'm just sorry, I'm thinking about that. I mean, they're from different sections of the ordinance. So yeah, I don't see why they wouldn't. If there's an interpretation that changes the way that this was viewed, it seems to me like that could still be heard.
Okay. They just don't want to get to the point to where it's like, oh, no, sorry. So they want to make sure that they would be able to have the administrative decision heard at the next meeting if they so choose so.
It's a different request. So the way the ordinance is worded, you can't resubmit the same request for a year after you've been denied. But it's my understanding the appeal of administrative decision is not a dimensional variance request.
Okay.
All right, so is everyone clear on that?
Yeah.
Okay, thank you very much, Kelly.
You're welcome.
All right.
I guess, Andrew, what's your thoughts then?
Well, given that, then we'll stick with, what's in front of the board, which was argument number 2, which is that maybe we don't even need to get to that point because we have here the grounds for a variance, as I outlined before, and I don't want to repeat what I said, but we have, and it's been in the minutes, it's been documented in the minutes for both the pool and for the decorative landscaping wall, that due to the unique shape of the lot, the severe topography of the lot, and the substantial justice of giving my client the required or non-required yard space that other people have in the surrounding area through no fault of his own would be grounds to grant this variance here and prevent the issue from going further and having to appeal on the erroneous interpretation and sort of upheave what the required and non-required yard interpretation is within the ordinance.
Okay. All right, we're going one more time. Does any board member have any questions for the applicant? Seeing none, I will open the call to the public this time. And as previously noted, there were 2 emails received today with correspondence speaking against the variance. All right, so we'll wait a minute and see if anybody calls in.
Okay, this is Stuart from Pine Ridge Lane. I'm a nearby neighbor.
Go ahead, sir. State your name and address again.
Stuart, 3540 Pine Ridge Lane. So to say that it's not a hardship is kind of hard to say. It's obviously building too much on this lot that's too small. That's one point. And the other point is to compare flagpoles and fire pits to a pool is kind of stretching it. But that's all I have to say. Thanks.
Thank you very much. Is there anyone else speak tonight or in the queue or tapping in via the Zoom link?
I do have one more person, Mr. Chair, Ms.
Okay.
Bettis.
Please state your name and address.
And let me see.
This is Donnie Bettis speaking. Can you hear
Please
me?
state your address.
My address is
I can't. Please state your address.
My address is 3430 Pine Ridge Lane here in Genoa Township. I've been a resident of Genoa Township for 33 years. I recently ran for state representative of District 42, which includes Genoa Township. Having just finished this campaign, I know how hard you all have worked to be here on the Zoning Board of Appeals tonight. I commend the board for meeting for the 4th time to deal with the Sliders petition. This petition asks to build structures closer to the lake than currently allowed, including a retaining wall and a swimming pool. The Sliders claim they have a hardship. This hardship, however, is self-imposed due to where they chose to build on the lot and the extensive excavation of soil near the hillside. This excavation raised the height of the hillside, and now they want to construct a wall to contain the soil that they chose to move to begin with. While I was campaigning for state representative in District 42, I had the opportunity to observe numerous lakefront communities in Putnam, Genoa, Green Oaks, Hamburg, and Brighton townships. Many of these lakefront areas are overcrowded, overbuilt, and unsightly due to the lack of guidelines and planning. Genoa Township, however, is known for its natural beauty and open spaces, especially around the lakefront. This is mainly due to our township's good stewardship and actively managing and enforcing zoning requirements. From all the meetings we have had on the Sliders petition, it seems the only ones to benefit from allowing it is for the pool company to make a profit, then they will be gone, and the Sliders to build an obstructive wall closer to the lake than guidelines allow. All against the expressed desire of the majority of neighbors who live within 300 feet. I ask the Zoning Board of Appeals to continue their good stewardship of our community and refuse the Sliders petition for once and for all. Thank you.
Thank you very much. Is there anyone else here to speak tonight or online? Is there anyone else in the queue?
No, sir, I do not see anybody else.
No one is accused, so we'll close call to public at this time and bring it back up to the board for a decision or discussion.
Can I add one other comment?
Are you a member of the public?
No, it's Brandon.
Who's that speaking?
Brandon.
Oh, so you're a member?
No,
Who
I
are
was just
you with,
asking.
sir?
What's that? It's Brandon, the guy
You're a
you've
member
been
of the
talking
public,
to.
correct?
No.
But what is the core question, Brandon?
Well, the core thing is twofold. So we're not seeking to change the existing grade. The grade has been changed through the course of construction, which is going to be restored to the approved grade based on the plan. I do want to point out, though, that the required setback, what we're trying to do is not get the required setback variance. There is a setback requirement for retaining walls that states that it is 10 feet from any lot line. That is the variance set forth for swimming pools. That includes in the waterfront. What we're seeking is not a dimensional variance. We're seeking relief from section 110405, which prevents anything other than a dock, mooring apparatus, and deck to be in the required yard. As you know, has been granted in numerous other cases throughout the Genoa Township, with both approved without ZBA and with ZBA approval. Most homes on the lake do have things that are built outside of the principal structure setback.
All right, thank you very much. With that, I'll bring it back up for the board for discussion and decision. Where's the druthers of the board?
With full approved without ZBA and with
Michael Balagna.
most homes on the lake do
3450 Pine Ridge Lane.
Who's Michael Belagno? Do we have somebody calling Amy?
Looks like he,
Yeah, I'm calling for the meeting. This is Genoa Township meeting.
it looks like he was a late add-in, Mr. Chair.
Okay, so we will reopen call to the public for this gentleman. Sorry, sir, there was just real difficulty with the Zoom. So please state your name and address.
Michael Belagna, 3450 Pine Ridge Lane. I would like to state that.
Go ahead, sir.
I'd like to state that the Sliders house is 20 feet in front of my house already, blocking my view, and putting up a swimming pool wall that they added dirt and made higher will continue to block my view. And it is a hardship to me, and I do not wish for them to be able to have a pool. I also would like them to move all the excess dirt that they have put there that's blocking my view. They already cut down all the trees, and they already removed their natural wall that the neighbor had been using for 40 years that had no problems getting down to the lake, and they created this hardship themselves. They were denied in February with the first variance they requested. And they could have moved the house back to make room if they want a pool. They still have room to put a pool in their courtyard. There's no reason. I don't know how many of you have been there and done a spot variance or look, but they have lots of room to put a pool right in their own courtyard. They don't need this additional land not to have a pool. Any
Okay,
questions?
Thank you very much. No, sir. Thank you very much. Is there anyone else to speak at public comment tonight during this discussion? All right, we will now close public comment again and bring it back up for the board for a discussion and a decision. What is the druthers of the board?
Mr. Chairman, this is Mary Ann McCurry calling. There have been many hours and much thought and much detail put into this specific property in regards to what is being requested for the township to give for variance purposes. The number one thing that comes across with every property regarding requesting a variance is what is the hardship with the property and is it self-created? I have heard numerous times that this is self-created. I've seen that it's been self-created. What did the property owner do to create the reason for asking for a variance? And this property owner asked to reconstruct a brand new house on a piece of property. And in fact, 2 years ago, requested a waterfront variance, which was denied because it didn't show substantial justice. It was self-created and it was too close to the water. So I don't see that what is happening today is any different than what happened in that time frame when the original was requested. We are talking about this property specifically, what they're requesting and how it relates to our ordinance. I am not in favor of granting the variances, and for the record, wanted to make my opinion noted.
Okay, is there anyone else? Do I see a motion coming?
I agree with Mary Ann. This is Jean Ledford. And I agree with Mary Ann and her ideas and her judgment. And I also will be voting against this.
Mr. Chairman, I have a motion to deny the request for the property at 3470 Pine Ridge 2018 for a front yard variance to install an in-ground swimming pool in the waterfront yard based on the following findings of fact. Strict compliance with the ordinance would prevent the applicant from building an in-ground pool in the waterfront required setback yard. This variance request is not necessary for the enjoyment of the rights possessed by other properties in the same zoning district and vicinity of the subject parcel. 110405 ordinance regarding waterfront accessories structures states only the following structures and appurtenances shall be permitted within the required waterfront yard are docks and mooring apparatus. It does not say pools. Number 2, a review as requested by the township manager to interpret sections 110403 and 110405 of the ordinance as relates to swimming pools was discussed at the last ZBA meeting. The consensus was that pools are not allowed in the required shoreline setback. 110403 states pools shall not be in the front or street yard. Number 3, further it was noted and agreed upon that in the absence of any conflicting regulations, section 105 of the ordinance states that the provision or the standard which is more restrictive or limiting shall govern. Number 4, the applicant was denied in 2019 by the Township Zoning Board of Appeals for a waterfront setback variance to construct a new home based on the findings of fact there was no hardship, there was no extraordinary circumstance, and the need was self-created. A clearly established review and explanation at that time was given regarding a waterfront variance. The extraordinary circumstances, and although the applicant has provided examples of properties in the nearby area with the same zoning noting in-ground pools, the only one property that is provided is not significant enough to note substantial justice when all other examples comply with the ordinance. In addition, it is noted that the need for the variance is self-created, and the applicant took action on this property to create a need for this variance by constructing a new home and creating the need for this variance request.
Okay. As
I
the
support-
motion, do I
Jean
have,
Ledford. Jean
do I have a
Ledford
second?
support. Second, Jean Ledford.
Jean Lefford? Is there any further discussion from the board? Seeing none, I'll call for the roll call vote. Mary Ann,
Aye.
Jean,
Aye.
Michelle,
Aye.
Bill,
Aye.
I vote aye as well. Motion passes 5-0. The applicant, if they're still online, can contact the township office to discuss the appeal process that was previously discussed. All right, moving on to our next item on the agenda, approval of the minutes of the November 17th, 2020 meeting. Are there any corrections?
Mr. Chairman, Jean Ledford here. Yes, I do have a couple. If you go to,
Jean, excuse me, Jean,
yes,
which meeting? Because there was 2 that evening.
this one was at 6:30,
Okay,
November 17th, 6:30.
okay.
Okay, on page 2 of the minutes, reference is made in the second paragraph about a septic field.
Yes,
And if I'm not mistaken, there is no septic field. Okay. On page 4, item 3 and item 4 are exactly alike. So I would suggest moving item 4. And then on the next page, page 5, make item 5 number 4. And that's it.
Are there any other corrections to the minutes? All right, Gene, is that a motion to approve the amendment minutes as amended?
A second.
Second by Michelle. Do we need a roll call, or is there any, can we do this by voice? All in favor signify by saying aye. Aye.
Aye.
Mr.
Anyone
Chair,
opposed? Yes.
I'm sorry, Jean asked to have the septic field in regards
Yes.
to property on Door Road.
There is a septic field.
There is a septic field.
Okay, thank you for the correction. I was wrong.
Everything on door, that's up there.
Yeah.
Okay, so we voted for that, and do we need to redo that again, or we just administratively handle that?
We can
That's fine,
administratively
sir.
handle that.
Okay. All right, that takes us to correspondence. Amy, is there any correspondence?
Excuse me, sir, there were 2 sets of minutes to be approved.
Oh, okay, excuse me. So Jean, we need a motion for which ones do you need a set of minutes for? We just approved the 6:31, right?
We need the 8 o'clock.
8 o'clock minutes. Is there any corrections to the 8 o'clock meeting minutes? All right, I'll take a motion to approve the 8 o'clock meeting minutes.
Motion to approve.
Second, Jean
Motion by
Ledford.
Michelle, do I have a second by Jean? All those, any discussion? All those in favor signify by saying aye. Aye.
Aye.
No opposed? All right, seeing no one. Member correspondence.
I will have the meeting schedules emailed to you tomorrow for 2021. And we do have a case already for the January 19th meeting.
All right, sounds good. All right, the member discussion.
Just as a clarification in regards to the second item on the agenda, there was no reference to a retaining wall. So in assuming that the applicant is not,
We turned down that request.
I do not remember the motion.
you don't remember the motion for the wall? I just stated for the pool.
So you did not make a motion for the wall.
Oh, okay.
Oh, boy.
I thought we really didn't need one for the wall.
Well, they did state
That was a separate issue.
that they said that those were landscaping boulders.
Which wouldn't require a,
Which they stated
Right.
would not be required for retaining walls.
They wanted a clarification of 110402 that would include landscaping. They did. That's nice, just from the minutes for the meeting. There was no change because it discussed
The minutes.
the pool, and then the minutes previous discussed the pool, and then it discussed the retaining wall in the notes.
So your motion today
cover the pool.
just covered the pool only.
Yes.
That's all I see, correct?
Where there were 2 items in there to be reviewed, correct?
Correct.
And is the applicant still on?
I do not believe so.
So what do you want to do? We can open it back up. The fact they
don't-
left is not my problem.
I don't know if we can, sir.
Why can't we? We're still, we haven't adjourned.
Let's see.
I mean, we can't table it because it's the fourth time, so I guess that's like a pocket veto.
I'm gonna read check the ordinance.
Yeah, this is Kelly. If it's okay, I can chime in. I guess, Marianne, was it your intent for your motion to apply to both, or was your intent for it to just be for the pool?
Well, my intent was to be just for the pool because I was assuming that they were two separate variants. It was a clarification of the ordinance. Is that correct? It wasn't really a variance for a retaining wall. It was a clarification of the 110401, right?
No, I'm
No,
sorry, go ahead.
Yeah, I mean, so today's request was, we kind of broke the staff report into two items. The first one being the pool, the second one being the retaining wall. It is, essentially one request from the applicant to build a retaining wall with a pool.
Right.
So, I mean, I partially feel like the motion for the swimming pool may or may not negate the need for the retaining walls.
Right.
But it's possible that the applicant could say, well, even without the pool, we're still interested in the walls. So, in a way, Mr. Rassel is right. The meeting is still open. I'm not sure. Is there language when you're done with the case that says this item is closed? Patty, do you know if there's anything in the minutes that closes it after the vote?
No, ma'am, it just moves on to the next item.
And there was no comment from the applicant.
Correct. I saw them leave the meeting. I don't think it can hurt. I think it would do more damage to not address, to leave that item outstanding.
Correct.
So I would just suggest at this point, let's go ahead and reopen item number 2 and call for a motion on the issue of the retaining wall.
Kelly, are you sure that would not be more damaging to go on?
I mean, they've requested kind of two separate variances, and we've only addressed one of the two.
Well, if they've left and they didn't stay for a continuation of the second, would it be construed from the fact that they left the meeting that they were no longer interested in the variance regarding a
wall?
A wall.
Potentially. I mean, we
I
do
think
have
you have
applicants at times get up and walk out of meetings if they don't like the way it's going. I mean, if you want to wait, I can contact the township attorney and see if he's available and get just a quick opinion from him. If you guys want to finish maybe some of your administrative business.
Okay.
Yeah.
Okay.
We have two options. I think we should just vote on it, kill it, and be done with it.
Kelly, I think we should go ahead with a second motion on the wall because it might come back to bite us.
Yep.
And this way we get clarification if we make the motion and either deny or approve the wall.
Sorry, I dropped off there. I think we should just reopen. Go ahead.
I agree with the option of reopen, finish that item. And
I think so too.
All right. So at this time, I'm going to reopen case 2018 to vote on for discussion on the retaining wall motion. Do I have a motion for the retaining wall?
Mr. Chairman, Jean Lightford, I'll make a motion for the retaining wall. I make a motion to approve the retaining wall because strict compliance with the required waterfront yard setback would prevent the installation
I'm
of
sorry,
the
I missed
retaining.
it. Did we get a motion?
Yes.
to approve the retaining wall in the
So I have a
required.
mo- so I have a motion. Do I have a motion by Jean?
Yes, I'm not finished yet.
Okay, sorry.
All right. To approve the retaining wall located in the required waterfront yard. Strict compliance with the required waterfront yard setback would prevent the installation of the retaining walls. The granting of the retaining walls in the required waterfront yard could provide substantial justice and may be necessary for the preservation and enjoyment of a substantial property right similar to that possessed by other properties in the same vicinity. This property has historically had retaining walls, and there are multitude properties in the area and around the subject lake with retaining walls in the required waterfront yard. The exceptional or extraordinary condition of the property is a topography of the lot. However, it appears that the property has had substantial grading since construction of the home, which included removal of an existing retaining wall. Granting of this variance will not impair adequate supply of light and air to adjacent property or reasonably increase the congestion in public streets or increase the danger of fire or public safety, comfort, morals, or welfare of the residents of Genoa Township. Approval of this variance is contingent upon the following. The applicant should ensure that grading on site will not affect neighboring properties. And the applicant must comply with the Livingston County Drain Commissioner and Livingston County Building Department final grading requirements, and that no railing should be installed on the wall. The proposed variance could have an impact to the adjacent neighbors in regards to the grading that has taken place on the parcel thus far. That's my motion.
The discussion is, I know we talked about last meeting on a case-to-case basis regarding retaining walls. And I know our township engineers supported the fact that there was probably the ability to just be able to utilize natural features for a retaining wall. Is there any thought or point in having this reviewed by staff prior to the actual implementation of the retaining wall?
I was under the impression.
Do we have a second?
Oh.
We're discussing it, Greg.
No
Wait,
second.
but who seconded? I got kicked out there for a second.
No second.
Okay.
I just had a question for
Okay.
discussion.
I was of the understanding that they decided to do boulders or some kind of ledge rock. So it would kind of correspond with the other retaining walls.
And what they submitted in their package was showing like a support of a whole terrace area. And it's complete, like a 90-degree drop of a ledge.
Yes.
So,
Trying to find it.
if a pool is not going in there, is that going to be, I mean, should it be noted that it needs to be similar to the submitted landscape plan that was?
Yeah, I'm sorry, the definitions of landscaping that they've got in their packet and they've highlighted in blue, is that, I'm trying to find where they pulled that. Treatment of ground service with live plant materials. We got to determine whether what they're allowed to do as far as stack stone live. They've got a combination of both here.
which is showing, I think, the natural features of, that they're trying to combine with what the township engineer stated, that they felt that that was able to be utilized along with a combination. If the picture that we're looking at now was the latest submission, I believe, Amy, is that correct?
This is the last submission, correct?
Right. So should it be noted that it should be should be similar to the page as submitted on, is it 10/23/2020 is at the top of this page?
Yeah,
Well,
I would say,
But aren't we dictating style then?
Yeah, I was gonna say, aren't we dictating style? That was the exact thought. I mean,
Well, a bit what I think, I'm not so sure we're dictating style as much as we're stating that here's where, you're requesting a retaining wall. Are we leaving that open, wide open? Or if they've already submitted this, it should be in similar consistency with the.
Well, I would view that as a reason to vote against the variance then.
Okay, just point of discussion, which is why I brought it up.
okay.
Yeah, I understand the point, but I don't want to have them bringing back, what kind of rock they can use, or style of stone, or style of wall, and the angle. If we're concerned about that, that's a reason to vote for denial.
Is there a height? Is there something in regard to height in the ordinances? Do we have to list that, or at least where it is cited for fences, walls, and screens, 110404?
That does not have a height requirement. Because they're not allowed in the required waterfront yard. 4 feet is allowed in the front, and you're allowed 6 foot on the side.
Well, not just that, Amy, but in the recommended conditions, based on the approval of the variance, I did say that the applicant must comply with Livingston County Drain Commissioner and Building Department. So wouldn't they have a say-so as to how high this wall should go?
No, not really.
leave that open for interpretation.
Right. I'm looking to see if they gave us a height on these, and it doesn't look like they did.
That's cutaway, I thought had.
Cutaway was a couple slides up.
Couple slides up.
I think you were at it a little.
Oh, now I'm back to that.
Look on it.
Let me open the packet up.
This is Kelly. I would just suggest that, if we're looking at a motion for the retaining wall, to be at a height not to exceed what's shown on the plans. And I think staff is capable of working with the applicant to make a determination.
Yep.
There's an abundance of material in the packets. I do believe we have a height on something in there, and we can use the drawings that are provided to make sure that it matches.
Perfect.
Their slide was 77 in case you wanted to look, but I don't know that it's real specific.
Kelly, should I add that to the motion somewhere?
Yes, I would recommend that.
That dimension looks like it's 10 foot.
Yeah.
Highlighted in green, vertical next to the occupant on the lower level.
So what are you amending to the motion, Gene?
Pardon?
What are you amending the motion to say?
Well, that the retaining wall will not exceed the height in the plans.
Perfect.
Help me out here. Let me word that a little bit better.
Yep, that's perfect.
Okay. Not to exceed the height in plans.
Do we have a second?
I'll second, but I also think it has to say, and then township staff can work with the applicant in regards to the completion of that and configuration. Correct, Kelly?
Okay, we'll add that to it as well. Not to exceed height in the plans, township staff to work with applicant.
Okay, so I have a motion and a second. Is there any further discussion? Seeing that, I'll call for the vote. We'll do a roll call vote.
All right,
Jean,
aye. Aye.
We do-
Mary Ann,
Aye.
Michelle,
Aye.
Bill,
Aye.
I vote no. So the motion passes 4-1. All right, that closes case 2018,
Yes,
I think, for tonight. Okay,
okay.
right, which takes us back down to member discussion. Is there anything else we missed tonight?
No.
All right, seeing none, I wish everyone a Merry Christmas and a Happy New Year and thank them for their patience tonight going through Zoom. Hopefully we can all get together in January. I'll take a motion to adjourn.
So moved.
Second.
Motion second, all those in favor signify by saying aye.
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 Opposed, thank you very much.